So, Lucy, those of us who are interested in media law and more widely entertainment law, a bit like me, were gripped by the Wagatha Christie case. I think it gripped the nation, really. People got very interested in it. But the last thing I expected to do would be speaking to you about a trademark, Wagatha Christie. So I believe there's been a registration of a trademark. Is that right?
Yeah, so over a year ago, a company, London Entertainment Inc., applied on behalf of Rebecca Vardy for the trademark Wagatha Christie. And it was a trademark that was opposed, so it took some time to make its way onto the register. But last Friday, it successfully achieved registration. And surprisingly, it's got a very broad specification. So the goods that are covered by this mark are wide ranging. So things like stationery, jewelry, etc., are all thrown in here.
And you mention all of those different things. I mean, I'm not sure I will suit my Wagatha Christie hoodie, perhaps. But on a serious note, what sort of things could this trademark, this name, be used for?
So anything that's detailed on the specification, that the goods could be supplied under that particular mark. And that's essentially the whole function of a trademark, is that you're able to supply products or services under that particular brand that you have protection for. So yeah, let's wait and see. Presumably Rebecca Vardy intends to bring out a whole host of products under that particular branding. And it's quite surprising that it's actually Rebecca Vardy who applied for this, given that really the whole term that was coined, Wagatha Christie, was really making reference to Colleen Rooney, not Rebecca Vardy. She was the modern day, exactly, Agatha Christie.
Yeah, and you almost wonder why she wouldn't just sort of want to move on from that. So then why register a trademark?
Well, like I mentioned before, Dominic, a trademark gives you a monopoly. So what essentially that means is that if anybody else, any company out there that tries to apply that particular branding to any goods, for example, so if anyone tries to, apply that logo, those words to a hoodie, say, potentially they're exposing themselves to infringement proceedings. So it gives the owner the right to prevent that. So on top of that, though, there might be opportunities for Rebecca to license that name to other companies. So it gives her the chance to commercialize this asset and make money from it through various licensing arrangements that she may decide to enter into.
And I know from having previously spoken to you, Lucy, how valuable intellectual property can be and trademarks. How can you help businesses who are interested in applying for a trademark?
So any business that is currently using a brand but doesn't have a trademark, we'd strongly recommend that you get in touch and you look to registering that particular brand and gaining advice on that and putting in place a sensible filing strategy around that. But also, and really ideally, before any business actually launches a brand, it's important to do a prior rights clearance search to check the degree of risk, both infringement and opposition risk, attached to launching that particular brand. And assuming the risk is acceptable, then go ahead and apply for a trademark, because then you're really launching your brand with the best possible protection in place, and we can help with that.
I'm Dominic Walker, JMW's Inside Man.